Welcome, everyone, to the CTIC event here at Penn Law on State of the Nation, Antitrust, Privacy, and Healthcare Law and Policy in the Biden administration. As the friends of this program know, this is part of our roughly monthly series to talk about various issues of interest, and both that are occurring in the news and in public policy, but also to allow the great experts we have in our faculty to share their thoughts of what different developments are and to provide their insights into those developments. As you probably know, we've done a number of these recently. In the last month, one on communications law in the new administration, another one on a recent development called the CASE Act, which is a major piece of copyright reform, and talking about different decisions. And today we have another wonderful set of experts and topics to deal with here of obviously of great importance to the country and to all of us who follow it. A couple of quick reminders. Today's event will be recorded, so everyone who is participating should be aware that the event will be posted on the web afterwards. For Penn Law students, there is an upcoming event, just so you know. On the 20th, we're doing a panel on careers in intellectual property by a number of distinguished practitioners. And actually, for those students who are interested in clerkships in the intellectual property space and technology law space, we're doing an event on Thursday at noon. If you're interested, please get in touch with CTIC and we can be happy to provide those details. And unfortunately, or just to let everyone know, this is the last one of these events we will do for the year. We'll resume again in the fall, but with the group of people that we have, I can't imagine a better topic or note to end on. So without further ado, I will turn the floor over to our first speaker, who is Allison Hoffman. Allison is a professor of law and an expert on healthcare law and policy here at Penn Law. Her recent work has examined such critical issues as the Affordable Care Act, Medicare and retiree healthcare expenses, long-term care, and the like. Has extensive experience as a lawyer and business consultant in the healthcare industry, having worked at Ropes and Gray as an attorney at Boston Consulting Group and the Bridgespan Group, and as previously a member of the UCLA School of Law faculty and a fellow at Harvard's Petrie Flom Center for Health Law Policy, Biotechnology, and Bioethics. Without further ado, Allison Hoffman.
Good evening, everyone, and thank you so much for inviting me to be part of this event, Christopher. I am going to talk about health policy under the new administration, and let me share some slides with you all to do that. Okay, hopefully you see my slides now. So I could spend the entire of this event talking about health policy under the new administration, what has happened already and what's likely to come. But I will go through it quickly and leave some time for my fellow panelists, and then I'm happy to talk more about the pieces that interest you all most in Q&A. We knew right from the get-go. We actually knew before the get-go. We knew during the Democratic primaries last year and then during the presidential election that health policy would be a core of the administration's priorities, no matter which administration that was. So that's proven true, and it revealed itself very quickly in the administration in the early days when President Biden turned quickly to health policy efforts through executive orders and executive actions. So I'm just going to include, I'm going to mention a few of the things that they noted as being priorities, that he noted as being priorities in the early days. And then I'll talk through a few regulatory efforts, what Congress has done so far, and what I anticipate is going to happen next, although some of that's a little bit of guesswork. And I'll if I have time, I'll talk about which one of those future priorities I think are most promising and which ones I think are less promising. So the administration, some of the early efforts and actually the continued efforts are trying to expand health insurance coverage and also access to healthcare. And a lot of that is just kind of rolling back and scaling back a number of the efforts during the Trump years that went in the opposite direction. So one of those, for example, was that one of the first actions was to open healthcare.gov. Healthcare.gov is the federal health insurance marketplace where people who buy individual ACA coverage can get those policies. So one of the first actions was to open that back up again. It usually only has an open enrollment window for a few months a year, and to say, people who want to sign up for coverage can sign up for coverage. Originally February through May 15th, and then has been extended beyond then. And also, the administration put out some money in enrollment support. So things like navigators and people who can help those who are trying to buy policies figure out how to do so. And the early news is that so far, about 500,000 people have signed up already, and more will come for reasons that I'll discuss in a moment. President Biden also instructed the agencies to re-examine a number of policies, some of which they've already begun to act on. Things like policies that undermine protection for people with pre-existing conditions, policies within the Medicaid program. Medicaid, for those of you who don't know, is the health insurance program for lower income people. And there were a number of policies that required people in that program to do things like engage in work and community engagement in order to keep their health care benefits. So he looked to the agencies and said, re-examine these things. Policies that made it more difficult to enroll in health insurance, whether it's private insurance or public insurance through Medicaid. He revoked some of the policies that made it easier for people to buy plans that didn't have all the Affordable Care protections, things like short-term policies that used to be in the Obama administration available only for a short period of time, a month or two, and then during the Trump administration could be kind of extended out to a year and more. And then things called association health plans, which were a way for people to gather together to try to create plans that also didn't have to comply with things like the benefits that have to be covered under Affordable Care Act plans. He authorized, as you all know, I don't have to say this, a lot of the early efforts have been on COVID. Both trying to get vaccines out there as quickly as possible and to continue to slow the spread as that's happening. And one of the things in that regard is that Biden authorized Health and Human Services to secure supply chains to fight COVID-19. Things like getting more PPE out there, getting the vaccines produced as quickly as possible. He rescinded the global gag rule, which is also known as the Mexico City policy, that bars international organizations who get US funding to provide abortions or counseling or referrals for abortions. And that one is one that flips back and forth one administration to the next on a regular basis. In terms of food security, he asked the US Department of Agriculture to expand and extend the federal nutrition program. So lots of efforts in lots of different angles. After he put those guidelines out there to the agencies started to act. So far, I'm just going to give a couple of examples here. We see that the agencies have been busy since and will continue to be very busy for a while. So a couple of examples that I think are pretty significant. On February 12th, the Centers for Medicare and Medicaid Services, CMS, said that they were going to start to rescind these work waiver requirements in the Medicaid program. The way Medicaid works is that states can experiment with different models of benefits, but they have to apply to the federal government for a waiver because the federal government pays for half of the Medicaid program. And so the way that these work waivers operated were that the states applied to, CMS invited the states to put work requirements into place, and a number of states took them up on that invitation. And so they applied to get a waiver to test what it would look like if people had to, what they called able-bodied people, had to work or engage in other kinds of community activity in order to keep their health benefits. And pretty quickly, the waivers were challenged. They were challenged both on substantive grounds as being inconsistent with the objectives of the Medicaid program, and on procedural grounds as having been approved without going through the administrative processes like notice and comment that are required for regulations. And we learned pretty quickly that what was the result of these programs is that large numbers of people lost their Medicaid benefits, 18,000 people in the early months in Arkansas. So the early legal challenges were successful. They were still these cases were being appealed, and oral arguments had been scheduled in the Supreme Court at the time that the administration started to pull back the work requirements. So they have terminated the waivers, the approval to do these programs in New Hampshire, Arkansas, Michigan, and Wisconsin. And they've asked the Supreme Court to vacate the lower court rulings and send it back to the US Department of Health and Human Services, back to CMS, in order to write new regulations. What's interesting is that the case at the Supreme Court is on hold now. They canceled the oral arguments, but haven't said yet what they're going to do with the rest of the litigation. So there's still a question mark as to what will happen there. A second monumental regulatory action was that the Department of Homeland Security rescinded a Trump administration public charge rule. And what the public charge rule says is that prospective immigrants who are likely to become dependent on public benefits may not be granted entry into the country, or may not be able to get green card citizenship status over time. And so the Trump administration public charge rule for the first time said that if it looks like you will be reliant on things like food and housing assistance or health benefits under Medicaid, you may be denied entry. And so that rule was also challenged, and the administration essentially, because the cases challenging the rule had been successful, and the administration simply said, okay, well, we're going to follow the court's ruling, we're going to remove this rule, and the rule that existed beforehand will be in place. And they reached an agreement to dismiss the case that was still moving up through the courts on the Trump administration rule. But now we have a number of states that are trying to intervene to defend the Trump administration version of the rule. So most people think that they're unlikely to be successful, but that one is still in process as well. And then Congress has been busy too in the healthcare front. So with the $1.9 trillion American Rescue Plan Act, known as ARPA, there were a few major efforts to expand access to health insurance and healthcare. So I'll mention a few of those. And first, let me start by talking about the Medicaid program, the program that provides health insurance coverage for lower income people. So a number of provisions in ARPA applied to this program, including a broad COVID mandate that said things like states have to cover testing, treatment, and immunization as a mandatory benefit. They have to provide this to all people in the program. They can't limit or exclude benefits covered in which COVID is the underlying diagnosis. So they have to cover benefits where there's a COVID diagnosis. And then they also said that states have to cover, with no limits, underlying health conditions that affect COVID treatment. So if somebody has an underlying health condition that could make them more susceptible for COVID, states have to treat those conditions. What exactly that means is hard to know, and I think there will be arguing about, what exactly are these kinds of underlying conditions that could affect COVID treatment that states have to cover. The law also said that there is no cost sharing, that people don't have to pay a share of the expenses for COVID treatment, testing, and immunization. And the federal government said to the states, we'll fully pay for those things. You don't even have to pay for your share of that. They expanded eligibility for the Medicaid program for people in a postpartum period for 12 months. Typically, people would have a very short postpartum coverage period and then would have to find coverage elsewhere. And then they also put a policy in place that's intended. So let me take a step back for a moment. The Affordable Care Act, as most of you know, if you follow the news or if you have taken constitutional law, put a provision in place that tried to expand Medicaid to everybody earning up to 138% of the federal poverty level. Just for reference, the federal poverty level for an individual is just under $13,000 a year. So we're talking pretty low income, up to 138% of that. And the Supreme Court said, well, you can't do that because it's coercive and it exceeds Congress's power, but you can leave that provision in place as an optional expansion. So states can choose to expand, and if they do, they'll get federal matching dollars, or they could choose not to expand and keep the old eligibility rules into place, which said you had to be poor and have another category of eligibility, like be under age 18 or be a pregnant woman. And so most of the states have now expanded, but there are still a handful of holdouts. And so in ARPA, the federal government said, we're going to offer you more money if for you states who haven't expanded yet, if you decide to expand. So what they offered was that we will pay 5% more of all of your Medicaid costs for everybody in your state in the program for a period of time if you expand now. And some states who have been holdouts for a decade now, like Alabama and Wyoming, are talking about expanding. Let me say a moment about what ARPA does on the private insurance side as well, which is there are a number of different things. I won't touch on all of them. So for example, it included increased subsidies for people who lost their jobs and wanted to retain their job-based health insurance through what's called COBRA. But the more monumental piece with regard to private insurance is extra subsidies for people to buy ACA insurance policies. So the ARPA bolstered the ACA subsidies for private insurance for 2 years. So what you're looking at here on the left-hand side is who got subsidies under the ACA. And there were about 17 or 18 million people who were eligible for subsidies. And those subsidies only went up to about 400% of the federal poverty level. So for that individual, it's about $50,000. For a family of four, it's about $100,000. And what ARPA did was it increased the subsidies for people up to 400% of the federal poverty level, and then expanded it to people beyond that. So somebody who's earning, in your light green bar there, 400 to 600%, or more than 600% could still get subsidies if the cost of the health insurance exceeded a certain percentage of household income. Now, here's what it looks like for an average benchmark. A benchmark premium is kind of an average plan for a 40-year-old in 2021. And what you see on the left is what they would have had to pay under the ACA. So the blue bar is what the individual would have to pay, and the orange bar is what they would get through subsidies. And under the ACA, somebody who's earning 100% of the federal poverty level would have their plan mostly paid for under the ACA, fully paid for under ARPA. As you move up, you can see that under ARPA, kind of if you look in the middle bars, somebody earning up to 200% of the federal poverty level gets an almost free plan. The tax credit pays for most of their premiums, and their required contribution is small. As you go out to the right-hand side are those people who are earning 400% of the federal poverty level, $51,040 for an individual. And under the ACA, they would have had to pay almost the entire cost of the plan. They still pay quite a bit. $4,000 for somebody who's earning $50,000 a year is still a significant amount to pay in premiums, but their tax credits go up. So the question is, what's next? In the short term, what looks most likely, what has been proposed as part of the next infrastructure package that is on the table now, is money for home and community-based services. This is a version of long-term care that happens in the home rather than in nursing homes. And as you could imagine, watching what's happened in nursing homes over the pandemic of the last year, there's an added desire to move more long-term care into the home and out of institutions. And so the efforts to do this is to there's two pieces of this effort to increase these services. One is to say to the states that this service, which used to be an optional service that they could provide under the Medicaid programs, becomes mandatory. And the second piece is that the federal government is going to put a lot more money, $400 billion out of the next infrastructure package, towards paying for these services, which have typically been so underfunded that even the states that do provide them have long waiting lists for services. What is going to come next is very uncertain. So 3 things that have been talked about, which I'm happy to talk about more in the Q&A. One is making those ARPA subsidies permanent. They're only for 2 years. And so a lot of people think not in the infrastructure package, but in the one that's likely to come after that, is an effort to kind of extend those long term. There's been a lot of talk about a public option. I personally think it would be not a great use of political capital and unlikely to move the needle all that much, but it's still being talked about as a possibility. And I include Pelosi and Sanders here because if you've been watching the health news of this week, you can see that they disagree. Pelosi thinks that the effort should be on that first one, making those ARPA subsidies permanent and kind of shoring up the ACA. And Sanders is talking about things like expanding Medicare by lowering the eligibility age to 60, 55, maybe 50 even. So what's on the horizon is unsure. I think what we can say is the next big infrastructure deal will focus on home community-based services and long-term care. And if there's another reconciliation package that comes after that, it will include probably at least one of those final 3 options that I've noted here. So let me stop here and hand it off.
Well, what a great place to stop. And thank you for getting us launched on such an interesting set of developments. Obviously, healthcare is one of the primary priorities of the new administration. So thank you very much for that. Our second speaker is Herbert Hovenkamp. Herbert Hovenkamp is the James G. Dinan University Professor and holds appointments both in the law school and at the Wharton School. He's been called the Dean of American Antitrust. Instead, he speaks with an oracle-like authority on all matters of antitrust. And so he is regarded almost universally as the leading antitrust scholar in the world. the author of the authoritative Arita and Hovenkamp treatise, senior surviving author, and in fact, active testimony, received many awards from the Justice Department and other places, book awards, many honors that go beyond mentioning, but I guess the most important thing to me is he's a good friend to me personally and has added a whole new dimension to my own work and the life of the students here at the law school, for which we are eternally grateful. Herb, take it away.
Thank you. Thanks, Christopher, for that totally undeserved comment, and thank you for this invitation. I'm going to get right to it because there's actually quite a bit of stuff, and I'm going to put up some slides as well. So just bear with me a second here. Okay, I hope you see now a slide that opens up with the antitrust policy in the Biden presidency. And I'll start right out with people. Lots of appointments that are antitrust relevant. And what do they signal about the direction of Biden's antitrust policy? First of all, we don't have a head of the antitrust division yet. The principal contenders are all people that I would characterize as pro-enforcement, more pro-enforcement than the Republican administration prior was, although I would hedge that a little bit because Mr. Delarime has been pretty pro-enforcement since he quit his job as head of the antitrust division. I would not characterize any of these three folks, John Sellett, Jonathan Cantor, or Renata Hess, as progressives or as neo-Brandeisians, that is at the far left. But a couple of them, particularly Renata Hess, is pretty pro-enforcement. Now, the Federal Trade Commission has had 2 vacancies for President Biden to fill. He has already nominated Lena Khan. She is a neo-Brandeisian and kind of at the far left of antitrust enforcement. She's been an outspoken critic of the platforms. She has to go through confirmation. I haven't heard anything about any opposition to her yet, but she's fairly young and doesn't have very much experience. So we'll have to see what happens there. We don't know yet who's going to be the chair of the Federal Trade Commission. Currently, Rebecca Slaughter is. She's a strong enforcement person and has developed a very good track record, but whether she will be, and she's acting chair right now, so whether she'll be the permanent chair or not, it's hard to say. The other thing coming out of the FTC in the next 4 years, at least possibly, is going to be competition policy rulemaking. Now, the FTC is engaged in rulemaking in the consumer protection area for some time, but this would be basically designing rules about antitrust policy to kind of fill in the numerous gaps that are left by the language of the antitrust statutes, which are very, very spare. I don't know yet that that's going to happen or what it will look like when it is happening, but it is a very lively topic of discussion. The other thing of note is that President Biden nominated Tim Wu, another progressive, to be a member of the Economic Council. Now, what does all of that mean? Is there kind of a progressive takeover of antitrust that would run counter to Biden's total record, which has been fairly moderate? I don't think it is. I think I would use more the model from Team of Rivals, if you remember that book by Doris Kearns about the Lincoln administration. I think Biden is trying to pick people of diverse backgrounds and ideologies, get some debate going with some differential opinions, and we'll see what happens. One of the reasons I think that is because of Biden's other actions. Now, this slide's a little bit complicated, but has to do with the relationship between output, that is output of products in markets, and antitrust ideology. one characteristic of both left-leaning or the neo-Brandeisian approach to antitrust and also the neoliberal, the kind of right-leaning Chicago school approach that we identify with Bork, is that both of them end up advocating for policies that reward reduced output. The left-leaning people, mainly because they're fairly disparaging of efficiencies, they're hostile towards bigness, they're not very concerned about things like breakups that might ruin scale economies or scope. So output is likely to go down under the neo-Brandeisian approach to antitrust. However, on the far right, the Bork, the neoliberal approach to antitrust, has generally done a version of the same thing by defending a so-called consumer welfare principle that actually counts corporate profits as part of consumer welfare. And as a result, output has been significantly lower than it would be under a more moderate approach. So, you know, if the goal of the antitrust laws is maximum output consistent with sustainable competition, then we're going to want to be somewhere in between those two extremes, over here somewhere. And looking at Biden's policies overall, first of all, the stimulus package that was passed last month. Secondly, the infrastructure package, which he has promoted and is currently being debated. It seems to me that Biden's entire economic initiative has been towards increasing output and benefiting labor. And labor, of course, benefits when output goes up. I don't see him developing an antitrust policy that undermines that by favoring lower output solutions. So, for example, I don't see him steamrolling through the platforms, trying to break up Google or Amazon in ways that are going to result in higher prices and reduced output. So that's my prediction. It still remains to be seen what happens. We do, however, have some antitrust cases involving the big platforms. In fact, they've kind of been front and center in the antitrust debate over the last several months, beginning already in the waning months, or the waning year, actually, of the Trump administration. The Trump administration did file actions in the Justice Department against Google and in the Federal Trade Commission against Facebook. I would characterize both complaints as being somewhat on the narrow side. I mean, the given wisdom is that both complaints were filed in the district court for DC. The Microsoft case is the closest analogy. It's 20 years old, but nevertheless, it's the closest analogy, and it came out of the DC circuit. And so these two complaints were kind of tailored around the conclusions of law in the Microsoft case. But of course, now the government still has, both agencies still have the power to amend these complaints at least once. The Facebook complaint at this writing, as of today, has been subject to a motion to dismiss, much of which has involved market definition. One of the problems with the platforms is exactly what market do they sell in. It's going to be a problem with Amazon. It's certainly a problem with Google. And in the Facebook case, where a motion to dismiss has been filed, the Federal Trade Commission is alleging a market for, quote, social networking services. And the motion to dismiss simply says that is not a plausible market. It's actually a kind of aggregation of a whole bunch of different services, gerrymandered in a way so as to ratchet up Facebook's market share. And that, I think, is going to be a pretty powerful argument. We'll have to see how that develops. There's also private litigation proceeding against Apple And Apple's on the losing side of public opinion on this, and I think there's a good chance that one of the government agencies will intervene, particularly with respect to the App Store. Basically, the story of Apple is if you own an iPhone and you want to buy any kind of software that costs money, including games, you have to buy it through the App Store. Apple then takes a commission, historically 30%, although under recent pressure, they've been lowering that. Google Play does the same thing for Android phones. And that's been the focus of the litigation against Apple thus far. So it's narrower. It's not a general attack on the platform the way that the Google and Facebook cases have been. Same thing with Amazon. Now, Amazon, I think, is a likely target of an antitrust complaint later this year. There already is some private litigation which mainly attacks what we call most favored nation clauses, and mainly in the ebooks market. Basically, most favored nation clause is an agreement in which Amazon agrees with book publishers that they will require any other licensee of ebooks to charge at least as much money as Amazon charges. So Amazon kind of creates an umbrella that protects it from competition. Lots of people have complaints about Amazon, complaints about employee relationships and so on. Most of them are probably not antitrust complaints, but we'll just have to see what happens there. As of right now, the government has not yet filed an action against Amazon. In legislation, the big bill that is going to be taken very seriously, the principal sponsor, ever since she was a presidential candidate, Senator Klobuchar. That bill has gotten bigger and more diverse as it is proceeded through several editions. It certainly will look different when it's passed, if it's passed, than it looks now. But very roughly speaking, about 2/3 of it ramps up merger enforcement. It adds monopsony to monopoly. Monopsony is basically monopoly power by buyers. There's a lot of debate about whether it's even necessary because current merger law already covers monopoly power by buyers. The substantive standard for mergers today is substantially lessen competition. This bill would change the term to create an appreciable risk of materially lessening competition. Is that in fact a different standard? And if so, how do you measure the difference? All good guesses. I simply don't know the answer. There is a presumption of harm that defendants will have to defeat if a merging firm has a market share of greater than 50% or certain minimum capitation requirements. So whatever happens, I think we're likely to see more aggressive merger enforcement coming out of this bill. There's also a provision that changes the monopolization laws, which currently prohibit something called monopolization, and would change that to language that says materially disadvantages one or more actual or potential competitors. I think the closest analogy I can come up with for that is that it would bring our approach towards monopolization a little bit closer to the EU approach, which identifies abuse of dominance rather than monopolization as the offense. And in practice, that has turned out to be a more aggressive standard. There's a provision that says you can show market power without a market definition. That's mainly a concession to econometrics. The process of measuring market power has become much more technical and as a result more accurate, but there's been a certain amount of judicial resistance to adopting it. The statute also proposes an Office of Competition Advocate, which would be a enforcement agency, but one that would compile data and try to issue policy papers mainly in behalf of consumers or small businesses. And then finally, a provision that limits implied immunity. Now, implied immunity is basically immunity in regulated industries, electricity, natural gas, a couple of other industries where there isn't any express exemption from the antitrust laws. However, the courts have fashioned immunities in order to prevent too many collisions between antitrust policy and regulatory policy. Then on the Supreme Court, I think this is my last slide. Yeah. There are two cases on the docket. Remember, we've got a more conservative court now. So it's going to be kind of interesting what we're going to see. Probably the most high profile case is one that involves NCAA limitations on compensation paid to student athletes or the ability of students to license their names, images, and likenesses for promotional purposes, like advertising, placing on video games, and so on. The historical rule is that adopted in a big antitrust case involving the NCAA was that the NCAA is entitled to protect the status of amateurism in sports, and that meant that they could absolutely limit compensation. An agreement between two employers to limit compensation would be per se illegal. And interestingly, in the oral argument, which was about 2 weeks ago, the justices seemed quite sympathetic with the proposition that student athletes are undercompensated, that universities, some of them, are making a bundle off of student athletes, and that amateurism has kind of turned into an excuse for not paying people who actually produce a lot of revenue for the schools. It raises a thorny bunch of issues, things like how it affects Title IX. Will women athletes and men athletes be entitled to similar forms of compensation and so on? Those are all battles that will have to be fought down the road, depending on what the Supreme Court decides. Second case, which has also been argued, FTC versus Credit Bureau, is a more technical case. It has to do with the Federal Trade Commission's equitable powers. The statute authorizes the Federal Trade Commission has equitable authority to issue injunctions and so on. However, for decades now, the FTC has used that authority also to mandate disgorgement, which means requiring defendants to give back any wrongfully obtained monopoly profits. And this issue, the reason it's so lively right now is because several of the more conservative justices on the court really want to pull back on the equitable powers or even the adjudicative powers of agencies. And it's pretty clear from the oral argument that there's a major concern that the FTC is asserting too much power, and I suspect they're going to have to pull back on it. As a matter of enforcement policy, disgorgement is a pretty important remedy. I mean, think of what the world would be like if police officers had power to do no more than issue warning tickets to speeders, right? We'd have a lot of speeders. Why? Because there's virtually no penalty. Well, if you take away the power of disgorgement, then the principal thing the FTC has in non-merger areas is a cease and desist order, which is simply a kind of a slap on the back of your hand and says, stop doing this. So I'm guessing if the Supreme Court takes away the FTC's power to obtain disgorgement, that issue will be ripe for legislation. And then finally, and I'll close with this, repeated calls now, particularly from the left, from his friends, basically, for Justice Breyer to retire. The reasoning is obvious. He's by far the oldest justice on the Supreme Court. They want to make sure that he retires at a time when the president is a Democrat and the Senate is controlled by Democrats. So, people want him to retire during the next 2 years. He is, in fact, by far, I believe, the most sophisticated antitrust thinker on the court. And that will have major implications for the future of antitrust on the Supreme Court. But you know as well as I do whether or not he's actually going to retire. Okay, that's all I have. And thank you. And I'll welcome any questions at the end of the session.
Well, thank you very much, Herb. Again, an area of tremendous interest right now and great developments. And in addition, we now move on to Lauren Steinfeld, who also is going to share with us her thoughts about the Biden administration and privacy, which is another area of tremendous importance and interest right now. Lauren is the Chief Privacy Officer at Penn Medicine and Assistant Vice President for Audit, Compliance, and Privacy. She leads and oversees HIPAA compliance and other privacy initiatives for Penn's 6 hospitals, 250 physician practices, and the School of Medicine's research program. She's previously served as Chief Privacy Officer for the entire university. As prior to joining Penn, she worked for the Office of Management and Budget as Associate Chief Counsel for Privacy during the Clinton administration, when she was instrumental in shaping and drafting the regulations for HIPAA, but as well as working on government data sharing, financial privacy, and HIPAA compliance and privacy matters, and previously served as an attorney advisor to FTC Commissioner Moselle Thompson. Most importantly, she is a lecturer in law here at Penn Law and my co-conspirator in teaching privacy for the last several years, Lauren Stein.
Thank you so much, Christopher. And I'll just agree with you that is also most importantly to me too. I have loved teaching with you, and it's good to see you, and also good to just be on the panel with my other wonderful co-panelists, though it's a tough act to follow. It's really, I think we're going to have Carlin showing the slides pretty soon. Okay, great. Okay. So again, it's a privilege to talk to you about privacy today and really thinking about what is likely to happen in the Biden administration. Carlin, if you could advance the slides. There are many ways to consider that question, and what I've decided to do is to focus on these components. So first is, will there be federal legislation in privacy under the Biden administration? Second, I want to talk about the rising prominence of the right to access one's own information and how that might turn into a focal point for legislation. Third, I want to compare thoughts on privacy legislation and cybersecurity legislation. And then lastly, to talk about the just truly amazing novel privacy questions brought about by COVID-19, testing, vaccines, contact tracing apps, et cetera. So it's a lot to take on. I'm going to do my best to get through within the time that I have. Next slide, please. So the question of will there be federal legislation, I want to emphasize, is not new. This, when I came to the FTC, I guess maybe we didn't go back that far, did we, Christopher? Prior to my OMB days, I was at the FTC. I know we did actually. And in 1995, that was the question. There's this thing called privacy. We know it's becoming a bigger deal. There's the growth of this thing called the internet. Repeat after me, HTTP : everything was new. We didn't really have a sense of what privacy would be, but we knew that privacy was going to be a big issue. The Federal Trade Commission took a leading role in thinking through the policy issues around privacy, and the main focus of that role was, should the FTC recommend that there be federal legislation? At that time, there was really strong opposition from industry to any kind of federal legislation around privacy. And instead, what industry did is said, look, you really can count on us. We can self-regulate. We can point to fair information principles that have been around for decades when it comes to regulating privacy, and we'll do it to ourselves. Later, the tides really started to swing when industry decided, many members of industry, of course not across the board, but many members of industry decided to support what they found might be inevitable, that there would be federal privacy legislation, and much better to be in there helping shape it, and also better to have a good public response to problems. We were starting to live in the era of security breach notification, where many companies were finding themselves on the front page of papers because of security problems, and they wanted to have a better answer to the public by saying, well, we actually support legislation in this area. So for the last 20, maybe 15 years, there has been this tide towards favoring legislation. The other driver is that the European Union considers US protections to be inadequate, and therefore puts very significant regulations around data flows from Europe to the US. And if we were to have federal privacy legislation, that would probably go quite far towards appeasing the Europeans, and that would also assist in our compliance efforts. So with all of this groundswell towards supporting federal privacy legislation, why don't we have it? These are the showstoppers. Agreeing on substantive requirements. There's a lot of ways to regulate privacy. We see it already in the different sectoral legislation that we have. Financial services has pretty light touch privacy requirements. Healthcare has very significant privacy requirements, and there's lots of in between. So agreeing on what the requirements and prohibitions should be is not simple. It's not straightforward. Also, the issues of preemption and private right of action are just huge. So industry is very, very dedicated, and it really is a showstopper that any federal privacy legislation needs to preempt state laws. Privacy advocates feel just the opposite. And the private right of action component, we have experience with. Some privacy laws have it, and there's a tremendous amount of litigation, and some don't. You know where industry and privacy advocates land on that issue as well. Okay, next slide. Thank you. So what are the odds? Positive indications. There's a lot of pressure from Europe, as I mentioned. There's also a proliferation of state laws. So California always comes first, not just in privacy. California was the first to regulate in security breach notification, requiring that breaches of data be reported to individuals and sometimes to the press. They have additional amendments that they are looking to, they then passed the CCPA just a few years ago to regulate the protection of personal data very similar, in a way that's quite similar to what the Europeans do. So they passed this comprehensive privacy regulation and started to pave the way for other states to do the same. Now they are trying to strengthen those requirements through additional legislation. Virginia and Washington have followed. And so the more state laws we have, the more pressure there is to have federal. There is a growing agreement on substantive requirements and prohibitions, and I would actually credit Europe and California for getting us there. Although there's been a lot of kicking and screaming along the way, really people have started to get used to a pretty extensive set of requirements in the privacy sphere through that legislation. And last, Kamala Harris is a Californian. California really has paved the way in terms of going into new substantive areas of privacy protection, and will quite possibly be supportive of bringing those kinds of requirements over at the federal level. Negative indications, writing privacy rules is really, really hard. I have my own experience with that, working with many, many others on the HIPAA rules. I'll talk about that a little bit more. There seems to be some strange political black hole, which results in privacy legislation just not getting passed. And the reason I say that is because there is a candidate for what I would consider one of the easiest federal privacy laws to write, and that would be in security breach notification. Currently, every single state has its own rule with a slightly different set of triggers as to when individuals need to be told about breaches, a slightly different set of timeframes as to when they need to be told, slightly different set of requirements as to whether it's an email, a letter, whether there needs to be a press announcement. But these are relatively easy policy differences that can be to resolve through federal legislation, and it just hasn't happened. Anybody looking at it from the policy perspective has agreed that this is absolutely ripe for federal action, and it just hasn't happened. The politics have not been able to support it. And so that's why it's hard to think that on that much easier policy case, based on that, that we could actually have federal privacy legislation in the more complex areas. And lastly, the continued challenges on reconciling views on preemption and private right of action. Okay, next slide, please. I think the most likely outcomes are that we'll end up copying the GDPR, CCPA types of rules and adopt those as federal legislation. There would have to be some kind of a compromise position on the sticky issues of preemption and private right of action. You might end up with, one side winning on one issue and another on the second. It's hard to, well, I'll talk about HIPAA in a little bit, but I will tell you that there's a lot of very strong views about preserving stronger laws. There's a lot of strong views about giving people the ability to have redress for the privacy violations. And it's going to take some, again, real political will and some finesse to make that happen. Another quite likely outcome is to do nothing. Again, this has been around for 25 years with lots and lots of interest, and we don't have it yet. And then another outcome, it's not discussed as much, but Kirk Nara, who's a great privacy thinker, has posited that maybe what we should do is have a very high level statute and kick the hard material over to the FTC for a rulemaking, preempt stricter state laws, don't have a private right of action, take on that compromise. And that way you start to get some legal authority, but the hard details get worked out on the regulatory plane. Okay, next slide, please. I want to talk a little bit about what HIPAA teaches us about federal legislation, and that's probably because I was so fascinated to work on it in my time at OMB and because I live it truly every day now. So I just want to make a few observations. And the first one goes to the fact that I think writing rules is hard and complicated. And so to give an example, in HIPAA, there was extensive policy debate about who ought to have access to health information without the patient's consent. What are the national priorities that are so important that data needs to be shared to further them, even if there's no patient consent? There are very complicated rules under HIPAA as to when information can be shared with law enforcement. There's one provision that says yes with a court order or other lawful subpoena. There's another provision that says even without that, you can share certain identifying information, and it's listed what that is to locate a missing person or fugitive or suspect or victim. There are other provisions that say, okay, you can share with law enforcement if there's a crime on premises. Very, very detailed rulemaking because there was so much attention to the policy tension between privacy and law enforcement. Similarly, that rulemaking had to understand healthcare so extensively as to cover things that what one might not have come up with on one's own, such as data needs to be shared to facilitate organ donation, to facilitate healthcare oversight. And the research rules also are pretty detailed to determine when research can take place without patient authorization. So that rulemaking shows that when you look closely at how industry works with data and you have that knowledge, you can get to policy outcomes, but it is hard work and it is compromise. And it's not the kind of thing that one can think Congress can do very easily. HIPAA does not have a private right of action. There is federal enforcement authority and AG enforcement authority, but individuals cannot sue. I would posit, and I perhaps recognize that I'm biased because of my role, that covered entities are quite aware and responsive to the regulatory demands of HIPAA, and that the private right of action is not necessary to make HIPAA compliance incredibly a very high priority. And that is certainly not just only where I am, that is pretty much everyone I've spoken to. So in terms of facilitating or incentivizing additional compliance, I would argue that you probably don't need it, the private right of action. But in terms of redress, obviously that doesn't happen under HHS enforcement. It doesn't happen under AG enforcement in general. No preemption under HIPAA. More protective state laws apply. That is very good news from a privacy perspective when it comes to people seeking behavioral health, HIV and substance use disorder treatment. I'm speaking just for Pennsylvania. Other states have other priorities for additional protection. But I will also say that those laws are often not modernized. For example, some of them have no accommodation for sharing information for research or public health, or even the use of contractors. So I only say that it's really hard for me to actually speak about almost anything privacy-wise without using a HIPAA lesson, because I do think it has so much to teach us about rulemaking. Okay, next slide. Thank you. The rising prominence of access. I wanted to mention this because that has been a really significant development over the last few years. In the fair information principle world of privacy, what matters most is providing people notice of what's happening with their data, giving them some choice around it, giving them access, the ability to see what is held about them, and keeping data secure. It's a little bit of an oversimplification, but it's pretty close. Access has become a very significant policy direction. It was true under the Trump administration, and it's already true under the Biden administration, in that HIPAA already required patients to have access to their information, but there was additional guidance to make that access cheaper and faster, and make sure there's no barriers to patients getting access to their information. Now, under the 21st Century Cures Act, which again, this came about in the Trump administration, but the Biden administration is very committed to this. There is a special additional requirement to make much more health information available to patients through portals, through APIs, through all sorts of new technology, because of the idea that patients need to be empowered with their own information. So many people don't think of access as a component of privacy protection, but it is in fact, perhaps less known and less discussed than notice and choice, or notice and consent, but it has become much more prominent. It's easier to agree policy-wise on the fact that patients should have access to the information held about them. So that might be another way to have sort of a foothold to get agreement in the federal legislative arena. Next slide, please. Thanks. How about privacy legislation as compared to cybersecurity legislation? How does it relate? I mean, I'm going to say that there's a lot that's different between privacy and security. And so you could pass a law that has components of both, but you really might not. You might handle them differently. So cybersecurity's focus is generally on preventing unauthorized access, the confidentiality component, and also on preventing shutdowns of critical infrastructure. So ransomware, being an incredibly high risk these days, maps much more to cybersecurity types of rules than to privacy types of rules. Getting cybersecurity wrong can have immediate and catastrophic consequences to society or regions or sort of groups, communities. The privacy focus is generally more about transparency, choice, appropriate use, minimization, proportionality, portability, all under the notion about what's authorized access. So cybersecurity's focus is on preventing unauthorized access. Privacy's focus is on rules around authorized access. Often the privacy consequences are more to individuals, not always, but they're just driven by different requirements and different impacts. So I could see them getting regulated separately. So I would say they both trigger important values. But again, usually you see legislation that's separately taking on cybersecurity or separately taking on privacy. And last slide. Thank you. Okay. I hope I've painted a picture of the fact that I think it's hard to write rules in privacy. And I think at the same time, we have gotten some good experience with Europe, with California, with sectoral legislation. So some areas we might be able to get some substantive agreement on. What I think is happening with COVID-19 is that totally new privacy questions are arising. that we have much less experience on, and they are changing daily. So, for example, there's much less regulation of public health authorities from a privacy perspective as compared to hospitals and health plans. And yet public health authorities are the ones now increasingly getting access to significant amounts of health information. So might there be additional regulation there? Maybe, but that is, again, new. Knowledge of COVID test results by close contacts. That's a new privacy issue. It has obviously ramifications that are very personal to individuals, but also has huge public health implications. Knowledge of vaccine status by employers and other institutions. I mean, this is really happening right now. States are starting to signal that it is acceptable and lawful for employers to mandate this. Other institutions, many institutions are already announcing that they're going to mandate vaccination before people can return to work, return to school. What do we want to do about that from a privacy perspective? Should it only be used for that? How do we protect it once it's in those institutions' hands? A national vaccine registry, authenticated documentation, all new. New technologies to facilitate socially distanced interaction. So telemedicine, work from home, what we're doing right now. There have been privacy problems that have come about. The Zoom bombing is probably the best example. So far, there have been technology solutions and business solutions, but there could be legislative solutions someday. And then we have regulatory waivers, and this has been very interesting to watch. Several agencies, maybe many is the better term, the FCC, HHS, certainly Department of Ed, has relaxed enforcement in key privacy areas for the purposes of allowing, for example, hospitals to stand up telemedicine quickly, to stand up community-based testing centers quickly, to report to public health quickly. They've basically signaled we will not be coming after you from a HIPAA perspective or a TCPA, the Telephone Consumer Privacy Act perspective, when you're trying to fight COVID. So we've been operating with those waivers for, in most cases, over a year, and lots of organizations have gotten used to them. And there's a real question about when they will be removed and whether that opens up a policy debate about whether they should be removed. So we have little experience to draw from. I think legislation is likely a long way away on these fronts, but I definitely think we need to keep talking about them because we need to get better at this faster, because the data sharing is more extensive now on in the COVID-19 world on health issues than we've seen before. And with that, I will close.
Well, thank you very much, Lauren. This is the stage. In the last 24 minutes, we invite all of the panelists to join us back on the screen, but more importantly, for the audience to submit questions. That is available through the Q&A function that's available as part of Zoom, and we hope that you will share them with us. While we're waiting for some questions to populate, I'll throw one out to all three of you. Inauguration Day seems a long time ago. And we'd originally had scheduled this event for a little bit earlier, but moved it for personal reasons of various kinds. If we had this event on Inauguration Day, what do we, instead of now, what is the thing we're talking about now that wasn't even on our radar at the beginning of the honeymoon of the Biden administration? What's the newest thing that's coming along the pike? Is it, or not, let me ask Alyssa, is there something new, major or big, that wasn't on the current administration's agenda when it took office in January?
In my case, I would say not. I mean, we were at an earlier stage of many of these things, but I don't think there are any big new developments. There's a motion to dismiss in the Facebook case. There's a couple of presidential appointments, a list of judicial appointments, but you know, it's just more stuff. It's not really anything that I would characterize as a substantial change in direction.
So I would say, as I mentioned in my remarks, many of these questions have been around for a long time, and so the answer would be no to you, Christopher. However, the vaccine, the rollout of the vaccine, the extensive vaccine sharing, I think those raise new policy issues. And then I would also say that I think there, and I didn't mention this, I probably should have, but given the sort of the power of the Democrats to pass legislation, I think that we're starting to see that there's more that can be done legislatively just because of the politics. And so there might be more activity on the legislative front to try to take advantage of the Democrats in power and get something done.
I was going to say that same thing, that we're seeing more legislatively than I would have anticipated. The fact that already one major relief bill has passed, now they're talking a huge infrastructure bill, and then the next piece of legislation after that, and it actually seems plausible that all three may pass, is what I would not have predicted, and quickly too. So I wouldn't have predicted that if we had been. But substantively, there's nothing that surprises me that's on the agenda.
So it's fascinating. In the policy conversations I've been in, many people, you ask them how likely is legislation to pass. And by looking at the 51 to 50 majority in the Senate, the answer is generally not likely. The flip answer, the second answer I get from them is, it's probably never going to get more likely than it is right now, which is a different statement. But it means that many of the advocates are highly motivated to try to mature as much of this as possible. So, Allison, one of the things I'm fascinated by is this infrastructure bill, which has two things going for it. One is that they're tying it to budget reconciliation, which allows them to avoid the cloture rules. And that's a remarkable development, but may cause some limits in terms of what they're doing. But the second is this move to make healthcare part of infrastructure. There was a great article on CNN that said the definition of the word infrastructure is going to be one of the most important things for the Biden administration. Do you think that's going to, I mean, given that we're talking about spending $1.9 billion right now, do you think that's going to get through by being able to characterize changing healthcare coverage as part of infrastructure, or do you think that's going to cause problems in terms of getting it passed?
I haven't heard anything in terms of it creating problems. I mean, it is technically infrastructure because it is built, it's shifting labor force, right? Like that's what we're talking about. And it's flow of money. It's moving flow of money from one place to another place. So I think that there are other pieces of the infrastructure bill that will be more contentious than the healthcare pieces. And most of the bills, although the $400 billion on home and community-based services is of course quite substantial, it's not the main focus of the bill. The main focus of the bill is, lots of other areas. And I suspect we'll see a lot more debate over whether those kind of fit the contours of reconciliation than the healthcare piece.
Christopher, let me add one thing about what you said a minute ago about the division between Republicans and Democrats. One of the very interesting things in antitrust right now is that there's more commonality of views than there has been. I mean, usually, historically, we think of Democrats as for more aggressive antitrust enforcement and Republicans as less. But the platforms have kind of pulled them together. I mean, today, for example, Josh Hawley, of all people, proposed a bill that would prohibit the major digital platforms from any mergers effectively. I think their motives are different, but there's a certain amount of overlap there. And I can actually see some variation of the Klobuchar merger bill getting support from both sides.
Herb, why do you think that's happening? I see that in the healthcare space too. It's like people who, used to be in very different places are now have kind of all coalesced on this concern about kind of a lack of antitrust enforcement and what that's resulted in healthcare.
I can't answer why it's happening in healthcare. I think the reason it happens in antitrust is because the antitrust statutes explicitly say so little that they invite all kinds of interpretation as to what they actually do. And so today, when a very left-leaning Democrat talks about antitrust, they're talking about bigness, political power, suppression of small business. When a right-leaning Republican talks about antitrust, they're talking about political bias, suppression of conservative speech, and things like that. But antitrust tends to become kind of a common dictionary term that expresses those concerns on both sides. I think Josh Hawley's proposal to prohibit the big four platforms, Apple, Amazon, Google, and Facebook, from further acquisitions, I think it's largely motivated by his views about ideology and how the platforms treat right-leaning expression, which really doesn't have anything to do with antitrust policy.
But it does say a great deal about how Trump has remade politics. The general populist move in Republicanism, which was not traditionally there, but also a lot of us have speculated looking at the hostility towards Amazon and its connection to the Washington Post. His hostility towards the AT&T Time Warner merger, and it becomes a very different set of dynamics that are motivated by a particular animus that only really comes together in the identity of the actor, which is they don't like the same actor for different reasons. But that itself is really shocking, because in going into the 2016 election, sort of those companies were in many ways paragons of all that was good in American enterprise. And now to go from that to a bipartisan target is a pretty remarkable sea change.
I agree.
The one thing
I think.
Sorry.
I was just going to say, from the privacy perspective, the ideology also has usually brought left and right together. It has generally been, from a polling perspective, favored, supported from people on both sides of the aisle, Americans and leaders as well. But the practicalities of compliance obligations, the hit on innovation, drive people to want to get some of those, like I said, the preemption piece front and center, the litigation risk front and center. I think it's been much more on the practical business operational level that you've seen differences in what policies are supported. But again, from a philosophical perspective, taking those more kind of day-to-day realities out, you usually have them coalescing around the general principle of privacy protection.
There's another dimension, I think, that's at work here that doesn't play as much into healthcare or antitrust, is the California initiative that led to the California Consumer Protection Act, and more recently now the enactment of state law, which is a big part of the move of the actors to support federal legislation. Is that the opposite now is not no regulation. It's slogging it out in 50 state houses across at a place where they don't have the apparatus to do that. And so that's why it's not just federal legislation, but one that includes a preemption component. Because if there is no preemption component, pass it, don't pass it, you're still fighting it out in 50 state houses. And that is a different vector towards bipartisan or broader support for doing something that doesn't seem to me as prominent in either healthcare or antitrust. The one interesting thing, though, is the politics of legislative committees. Many times you would see issues about privacy being tied up with issues that are the province of the Commerce Committee. And because there are different sets of legislators, you can't cut the deal. Mm-hmm. Privacy goes to judiciary just like antitrust. And because they're the same actors, I could see there being easier to cobble an antitrust privacy-oriented legislative deal because it goes to the same committee than you can in some of the others. I'm sorry, Lauren, you're going to say.
No, nothing. I think you're right. I think that makes sense.
So, but the funny thing is, my assumption has always been with a 51-person majority in the Senate, and the reality that cloture rules are still going to be in place, that there was really no hope for major legislative reform. But all three of you have expressed some, I don't know, a hope or optimism. Maybe optimism is too strong, but really hold that as a possibility in a way that I would not have expected Is it
because Biden has just been a bundle of surprises? I mean, I've known Biden as not personally, but as a political figure for my entire life. And the Biden who was elected president is not exactly the same guy who was vice president and then senator and so on. And suddenly, I think there's a broad feeling that we may get something out of this guy that nobody really expected.
I agree with you, but I want to draw you out a little, Herb. What's the difference what's the surprise?
I say that again. What's the what?
What is the new, how is the new Biden that gives you that kind of expectation now different from the old Biden you've known for years and years and years?
In antitrust policy, he was always moderate to conservative, don't rock the boat. I mean, I would never have expected a $2 trillion infrastructure bill from that Biden. I think he's just listening to more people. This is his last shot. This is going to be his last big thing, and he wants to make an impact. And that's the kind of press he's getting, certainly from the Democrat press. They think of him, the number of articles recently that have compared him to Franklin Delano Roosevelt is just astonishing. I never would have expected that, but here we are.
I mean, you also have the impression with him that he seems like a person who is watching the clock and knows he has really limited time to get a huge amount through, to the point where he was ready, on day one. I suppose all new presidents are, certainly modern presidents, but they had a playbook. It was so clear on every policy issue, so that he was, executive orders, what public pronouncements, spanning an array of issues, certainly obviously COVID, but well beyond that also. So that's my impression of him, is he looks like someone who's waited a long time to get things done in the country that he believes in. And he's got that time, he doesn't have much of it, and he wants to push. And he's got the Democrats to back him.
Allison, is that your sense as well?
It is. When I watch what's going on, I think about two pieces. I think in the healthcare space, there was a lot to clean up. There was just a lot that the Trump administration did that was really harmful, and also that was really messy. And so they were ready. They hit the ground running on day one, ready to kind of move across the board on these initiatives. But something I see him doing as well is envisioning what the future of the party is going to look like, both from a policy perspective, but even more from a personnel perspective. When you think about who he chose as his running mate and who he's appointing to top positions, I think he's thinking about legacy more than most presidents do at this phase in their presidency.
Just think of where we would be if one of those two runoff votes in Georgia had gone to one of the Republicans.
Right.
Because I can tell you that right up until the day of that election, I was not at all willing to predict that there were going to be two Democratic victories coming out of those two elections, but it's made an enormous difference.
Please go ahead. No, Lauren, please.
I was just going to say, as I think about this, that it may be that where the policy is baked, like it's fully baked, it's been around for a while. People have had conferences like these and advocacy, and there's a pretty clear view about where they want to go. It seems to me they're just willing to go there. And in the case of privacy, as I mentioned, the sort of traditional issues have been around for a while. GDPR and CCPA even have been around for a while. Yes, they've changed here and there, but we have some experience. So it's more likely that he has a thought on where he wants to go with that. And so that would argue for legislation. I don't want to dismiss either the role of the pressure from the Europeans as well. So that would be another reason for him to go on legislation. But you still have some sticking points that he'd have to get through. But I just want to sort of put it out there that there's always thought about where to propose laws. And I think where the policies have been around and the trade-offs are clearer, you get movement.
what I've admired about this administration so much is its discipline on message, policy message. He has 6 priorities, right? Healthcare, COVID, immigration, Black lives, racial justice, climate change, and I'm dropping one. There's a 6th one on the list, but it's the same list. You see it. It's clearly a talking points list being circulated by the administration. And then it had a day on each one, rolling out all their initiatives really in a beautifully crisp way. And what's so striking to me is that Allison's issues are on that list. Lauren's and Herb's are not. Yet both Herb and Lauren see possibilities of legislative movement in a non-priority area. Now, Allison, I get, this is one of his centerpieces. He campaigned on it. And it's a question now, more or less, of what he's going to push as opposed to whether he's going to push. And so it brings up 2 questions, which is for Allison, is he pushing in the right places? Is there some expediency in making him redirect his agenda in certain ways? And second, for Herb and Lauren, given that your issues aren't on that shortlist agenda, why do we think that it's going to happen? Allison, why don't we start with you? Is he going in the right ways, or is it redirecting, or in healthcare?
Everything so far, I think, is good. So I see quick movement in lots of really important directions. I think the efforts to kind of shore up coverage and to get more people back in the health insurance markets in the short term, the efforts on the COVID front, all of this has been just feels right on to me. The whether the next step will be is to be determined. I would personally be very disappointed if I saw him investing a lot of his capital in the public option. I think that an individual, kind of adding an individual public option into the marketplaces after an infusion of additional dollars to get people to get into those marketplaces won't do a lot of structural good. I think in some markets where there haven't been a lot of insurers offering policies, it could do a little bit of good, but I don't think it'll do all that much. And I actually think the additional subsidies flowing into these marketplaces will make it more attractive for insurers to want to play, and that'll have more improvement in the kinds of things that a public option in theory is supposed to do than the public option itself will. And it will be a tremendous political battle. And if he's going to want to wage war in healthcare, I think there are a lot of other places he could do that would have more fundamental kind of promise in the long term to improve both either healthcare financing or healthcare delivery. So far I have thumbs up everything that I've seen, but I'm watching where he'll go next with great interest. And he might not go anywhere. I actually think I wouldn't be surprised if we didn't see I wouldn't be surprised if what we saw is an effort to keep those subsidies permanent and not much else in the healthcare financing space. But I think it's anyone's guess at this point.
Well, it's amazing. You're saying thumbs up to everything. Did he miss anything? Everything he's doing is good. Is there a dog that's not barking?
Let me think about that while others are weighing in.
So Lauren and Herb, why, if you're not on the short list, how is this going to happen?
Well, with respect to antitrust, I don't think legislation is a sure thing by any means, because it isn't at the top of the priority list. I think it's more likely today than it has been at any point in the last several years, including the Obama years. I do think that what is at least close to a sure thing is we're going to see more litigation. The next head of the antitrust division is going to be more aggressive. A new Democratic-controlled Federal Trade Commission is going to be more aggressive. Biden is not going to voluntarily dismiss the Google and Facebook complaints. They're going to be amended, and if anything, expanded. So I think in litigation, we're going to see some stuff. I'm not quite as sure about legislation.
So I don't know if there will be legislation, but I'll sort of expand a little bit on what I said in my earlier remarks. There is agreement on substance, and I'll tell you the 2 key bills, Senator Wicker and Senator Cantwell are the ones who sponsor the major Republican and Democratic contenders for legislation, have a lot in common. And what they don't have in common, again, is preemption and private right of action. That's what's standing in the way. Europe is pushing it along. But to your point, it's not a top priority. I suspect that there are draft bills sitting in various agencies right now, so that if and when the time is right, they can be proposed. Usually in privacy, the time being right is some terrible news story about a particular event, be it, Snowden or SolarWinds or whatever the big privacy snafu of the day is. And at that point, maybe the FTC, maybe the FCC, maybe Commerce, NTIA, whomever will, go to the White House and say, we've got a bill that we think can respond to this. I will say, and I hope I made it clear earlier, getting these things right at the detail level is hard. And I hope that it's not done too casually, because regulating data flows really matters.
I have one thing to add.
Please.
I know we're going to move to wrap up in a moment, Christopher, but the thing he hasn't done anything on yet, I guess I'm not surprised he hasn't done this, so it didn't come to mind right away, is on prices, on healthcare prices, which are really quite problematic. We hear about drug prices and whether Congress will act on drug prices, which they may or may not. But I guess I'm not surprised, because I wasn't expecting him to lead out of the gate with that, and they may get to it at some point in the next year. And I hope they do. I hope that's an area where we see movement. But I wouldn't be surprised if that takes a little while longer.
That's wonderful. So the last thing I'll do on a quick run through everybody is prediction. This thing we do, which guarantees we're almost always going to be wrong, but hey, it's kind of fun. If we have this same event next year, what will we be talking about the Biden administration having done or about to do, or what will be the news that we will be wanting to talk about a year from now? Some guess as to what you think it might be.
For my field, it will be litigation against the platforms and judicial appointments. I don't know what the outcome will be, but I think those are big issues.
I was going to say litigation as well. I think that a lot of the rollback of the waivers will be challenged in court, public charge rule. I don't think that the states will be able to intervene, but possibly I think we'll see a number of legal challenges the same way that we did in the Trump administration, and that's what we'll be talking about a year from now.
Lauren, you get the last word.
Hey, I think we'll be talking about more state legislation and how consistent or inconsistent they are with one another, and whether that is going to put more pressure on, as well as whatever the Europeans have done recently and which way that cuts.
Well, it occurs to me that probably both Herb's and Allison's answers is very good news for our students. Lots of legal work to go around, but we live in extremely dynamic times, which is, I suppose, a Chinese curse, but a reality. And fortunately, it sounds by the tone of everyone, the dynamics are positive. And so I'll take that as a good development, and thank all of you for sharing with us your insights, your predictions and expertise as to how the initial days of the Biden administration has gone and how it's likely to unfold in the future. We'd like to thank all the audiences for joining us, and we look forward to welcome you to a future event when the next one we rejoin and start these up again in the fall. Thank you.